Hi guys, my name's David Campanile. I'm an attorney in the state of New Jersey, and my firm is Campanilla Law, LLC. Now, I've started this vlog series to go over common issues that I pop up with or occur with clients when they sit down and try to go over a will or their estate plan, or even when I'm talking to owners in the New Jersey craft beverage industry. And today I really want to focus my attention on guardianship when it comes to estate planning. Now, the common misconception is that when you label a guardian in your will, is that if something happens to you, well, your children are taken care of. Well, that's a true fallacy. The issue here is if you only state your guardian in your will, that will still needs to be probated by the surrogate court in New Jersey. This could take 3 days, it could take a week. But now what happens to that minor child? Well, I hate to break the news to you, but the state can come in and take your child and put them into the foster system until your will's been probated. This leaves drastic, devastating effects on the children, especially younger children. So we want to avoid that. So what do? Well, at Campanilla Law, we devise a guardianship plan, which is basically a separate document from the will that can be put into place immediately upon the incapacitation or when a parent can't make a decision anymore. For example, let's say you came down with COVID-19. I know it's too real today, but let's just use this as an example. A single parent comes down with COVID-19 and is placed on a ventilator and placed in a coma. Well, what happens to their child? They would have to, that guardianship plan that we've drafted separately from the will goes into effect. Now we've named the guardian, we've given them the rights basically of a parent. They can make financial decisions, they can make education decisions, they can make child rearing decisions since the parent is incapacitated. Now when the parent comes off the ventilator, that guardianship plan goes back because now hopefully the parent can take care of their child again. Same kind of thing with a will. Let's say you're a single parent, go to a adults only resort, and you've left your child for 5 days with your parent or with your mom and dad, and you go and your plane crashes, you die. Well, your kid doesn't have a parent anymore, right? And it sucks, but you've only mentioned your guardian in the will. Well, the state can come in and take your kid. That's devastating. Whereas what I'm talking about is a separate piece of paper, very simple to draft. We do it all the time at Campanilla Law. Our clients really appreciate the insight that we give into this, and they don't have to worry anymore if something happens to them, that their child is taken care of. That is always the number one concern when I'm talking to a client is my child taken care of? Always something to keep in mind when you're speaking to your attorney about an estate plan. If you have young children, mention you want a guardianship plan too, because that's something that we can protect children and make sure they don't have to go through the harmful effects of potentially the state coming in. Thanks for watching this video. Stay updated. Any questions, you can reach us at www.campanillaLaw.com.